Morning, everyone. We'll just wait for everyone else to join and then we'll get started. Okay, we'll make a start. So good morning, everyone. Thank you for joining us today. My name's Kat and I'll be managing the webinar behind the scenes. Just to let you know, all your cameras have been turned off and your microphone's muted. But if you do have any questions during the session, please use the Q&A button at the top of your screen. Juliet will go through questions towards the end and answer as many as possible. And just to reassure you, today's session is being recorded, so there's no need to worry about taking notes. The recording will be sent out to you after the webinar. I'll now hand over to you, Juliet.
That's great. Thanks, Kat. Hope you can all hear me okay. I'm sure Kat will give me a thumbs down if you can't hear me. But yeah, as Kat said, there is a Q&A button at the top of your screen. Please use that for any questions, and we'll try and get to as many as we can. There is quite a lot of content to get through, having said that. But thank you, Kat, and good morning, everyone. It's really lovely to be here, and welcome to today's webinar on the Employment Rights Act 2025. And we're going to look at what's coming in, but we're also going to look at how it impacts your business and some of the key things you can do about it. So let's go on to the next slide, please, Kat. So I'm Juliet Price. I've been working in HR and employment law for over 30 years. Yes, that's me in the pictures back in 1997 when I graduated in human resource management. I'm also the proud founder of and managing director of Park City Consulting. And we're here to help businesses just like yours to stay compliant and grow with confidence. Let's move on to the next slide and have a look at who Park City are. So Park City are your award-winning business partner, really, for outsourced HR, health and safety management, and management and leadership training. We serve hundreds of clients in different industry sectors such as care homes, golf and leisure, manufacturing, service sector, retail, finance, and IT and tech sector. But let me start today by asking you this. How confident do you feel about navigating what is the biggest change in employment law the UK has seen in a generation? Well, that's exactly what we're going to tackle today. And let me tell you, recently I met with the directors of small localish engineering business. And the directors openly shared with me how overwhelmed they were, spinning a lot of plates when an employee raised quite a lengthy grievance. And they said it became clear just to them just how exposed they felt. What they found when they became a client with our retained HR service was immediate relief and clarity. Instead of one-off advice, they now have ongoing access to a dedicated HR business person, a business partner with in-person meetings. And the directors described it as a breath of fresh air and told me that starting to see all of these changes in employment law with the new Employment Rights Act, this only reinforced their decision to outsource to Park City was the right decision, as it confirmed that they wouldn't have been able to cope with all these changes alone. So I'm really happy to share that with you today, and hopefully we'll be able to help you as well. So why am I sharing this with you now? Well, because the timing couldn't be more important. So in 2026 and 2027, we're facing one of the biggest overhauls of employment law in a generation. The changes are deep, they're complex, and they'll impact every business. So this is not just the big corporates with big in-house teams. This is small family businesses and growing organisations just like yours. But the key thing is, I don't want you to get caught out. So that's why we deliver these webinars for free obviously to our clients and to other businesses, so that you know that we're here for you and we're here to help. But be under no illusion. A downloaded template solution to implement these changes won't be sufficient. The nuances of the changes are so significant, and understanding kind of how the changes will impact your business means that you really need face-to-face HR consultation and guidance on how to apply it. And that's why more and more businesses are turning to us for help. And that's why today on the webinar, I'll not only give you an employment law update on the new Employment Rights Act, but I'll also introduce you to the 6 steps that Park City have developed, a proven compliance plan to help you manage these changes with confidence. So if you're feeling stretched or overwhelmed, unsure how to navigate what's coming, you're in exactly the right place. Right, let's get started. So on to the next slide. This is what we're going to cover today. So the Employment Rights Act 2025, I will walk you through the latest update since the bill came in and became an act just before Christmas. I'm going to talk about what changes are coming in 2026 and the challenges for businesses. The 6-step process I mentioned we'll touch on towards the end. This will cover the steps you need to take to protect your business now. There will be a live Q&A. I really hope to get to some questions, but I'm conscious as well that there's a lot to get through. Please do sign up for Park City's updates, both on email and on social media as well, because that's where we'll be posting updates as things change through the year. And that's where you'll get invites as well to our live webinars, which again are free and will give you all the information you need. Okay, next slide, please, Kat. Right, the Employment Rights Act. So the Employment Rights Bill was first put before Parliament on the 24th of October 2024, and it became law on the 18th of December 2025. As a result, over the next 2 years, UK employers will face one of the most significant waves of employment law reforms in decades. Most of these changes will come into effect in the usual employment law windows of April and October. Not all of them, but most of them. Okay, some are coming in this year and some are coming in next year, 2027. Well, why is it so important to keep up to date with this piece of legislation? You might say, you know, I've been running my business for 20 years. Why is it suddenly so much more important now? Well, as business owners and directors and managers, you already have enough on your plate, running the business, managing the teams, keeping up to date with day-to-day operations, running the business, keeping it all on track. Well, the risk has increased. So if you don't prepare now, you will face higher unplanned costs, risky costs of stressful legal claims, and unnecessary disruption. The opportunity for legal claims is much greater, and the fines levied are much higher. These changes are high impact, both in financial risk and the impact of reputation and, you know, just the time drain on you when things go wrong. So next slide, let's look at the first thing that's coming in. So we're moving to April, as you can see on the little banner on the screen there. So the statutory pay rates all increase in April. That's nothing new. Every year they go up pretty much. So from April, these rates will be going up: statutory maternity pay, statutory paternity pay, statutory adoption pay, statutory shared parental pay, statutory neonatal care pay, and statutory parental bereavement pay will all increase from the current £187.18 to £194 £2.32 per week. And the lower earnings limit for employees to qualify to be eligible for these family leave statutory pay rates will increase from the current £125 to £129 per week. Next slide, please. Statutory sick pay. There are big changes to SSP from April this year. Statutory sick pay, the rate will increase from £118.75 to £123.25 per week. But from April, this is another big change, the current 3 waiting days for SSP will be abolished. So SSP will be paid to workers from day 1 of sickness absence. And the lower earnings limit to qualify for SSP, currently £125 per week, will be removed. This means that all employees, regardless of their earnings, will be eligible for SSP. And this will be paid at a rate of either 80% of their weekly earnings or the new flat rate of SSP from April, £123.25 per week. Whichever of those is the lower is what the employee will be entitled to receive. Now, the new law means that all workers will be entitled to be paid SSP from day 1 of sickness. And as a result of these changes, there are a few consequences that you may see as a result. Firstly, obviously, the increase in cost. And if you currently only pay SSP, more people, of course, will qualify for it and be paid from day 1 of sickness. The second thing that might happen is a change in employee behaviour. You may see more short-term absence. This may increase because, the 1 or 2 day absences, some employees who may have otherwise, struggled into work for the first 3 days because they were not going to get paid before, may now be off sick. Thirdly, you've got what is now the enforcement police. I'll come on to that a bit later. With the introduction of the Fair Work Agency, focusing on SSP and any errors in payroll, that makes it open to scrutiny and enforcement. So what should you do? What can you do about this now? We'll review your SSP, your sick pay policy, actually. If you enhance SSP and pay more, check that what you're paying remains competitive and ensure that managers are having return to work conversations with people. These are much more important now than they were before in managing absence and costs. Okay, next slide, please. National minimum wage. So from April, these are the increases. So for those aged 21 and over, the national living wage from £12.21 will increase to £12.71 per hour. This is an increase of 4.1%. For those aged 18 to 20, it'll increase from £10 an hour to £10.85 per hour. This is an increase of 8.5%. For those aged 16 to 17 and apprentices, from £7.55 to £8 per hour, a 6% increase. Now, you might notice that most of those percentage increases are much higher than the private sector are likely to be able to afford. Okay, next slide, please. So let's look at 2 forms of family leave that are going to become day 1 rights. So statutory paternity leave, currently this is 2 weeks for fathers or partners, and it currently requires employees to have at least 26 weeks of continuous service, which is basically about 9 months, at the 15th week before the expected week of childbirth, or in the week their partner is notified of a match for adoption. The new law will provide paternity leave from their first day of employment. The day 1 right to paternity leave only applies to the leave element, not the statutory pay element. Parental leave. Currently, to be eligible for unpaid parental leave, the employee must have at least 1 year of continuous service. The new law will provide unpaid parental leave from their first day of employment. So, run a scenario, an employee, a new worker starts working for you in April this year and could immediately request paternity leave or unpaid parental leave. Managers will need to prepare, therefore, for more workers to have an entitlement to claim time off. So this is about resource management, isn't it? And thinking ahead and just awareness and being prepared. Okay, let's look at the next slide. So the next slide is about sexual harassment. So sexual harassment, it's about the disclosures and whistleblowing. So the whistleblowing law protects workers who make a protected disclosure about wrongdoing by their employer. It protects them from detriment or dismissal. The list of wrongdoings currently includes things like criminal offences or a health and safety risk or breach or a cover-up. And currently, there's no protection for workers or whistleblowers if they raise the alarm about sexual harassment. The new law, however, adds sexual harassment to the current list of protected disclosures. This means that if an employee raises a complaint or speaks up that they reasonably believe sexual harassment has happened, is happening, or is likely to happen, they will gain whistleblower protections from detriment or dismissal. Now, this is high impact for employers because if they dismissed an employee for making that disclosure, it would be automatically unfair dismissal, with an employee needing no minimum service and no cap, therefore, as well on compensation coming up. Whistleblowing policies and protocols will obviously need to be updated here, management training and guidance. Okay, next slide. Let's look at collective redundancies. Okay, currently, collective redundancies apply when an employer proposes to make 20 or more redundancy dismissals at one establishment within 90 days, and the tribunals can make a protective award if you get a collective consultation process wrong. The protective award is currently capped at 90 days pay per employee that's been affected. The new law includes doubling the maximum protective award for failure to consult or getting collective consultation wrong from 90 days to 180 days pay per affected employee. Now, this change will apply to redundancy processes made on or after April 26, and there are also proposed changes to the collective consultation threshold in 2027. We'll cover that in a future webinar. So if you're thinking of restructuring this year, this is a really important change, and it really increases the risk profile for your business. A rushed or a non-existent consultation will be twice as expensive as it is today, on top of any unfair dismissal claims, which will be uncapped. What I would say is don't get overly stressed about consultation processes, but you do need to understand what they are, how to apply them, and you do need to apply them properly and make sure they're meaningful. So it's really important with redundancies to get some guidance and some help. Okay, next slide, please. Trade unions. I won't dwell on this too much because we'll come on to it in a bit more detail in future webinars, but it can affect all businesses potentially. So this is about simplifying the trade union recognition process and bringing in electronic and workplace balloting reforms. So if you're already unionised, consider updating your internal protocols for industrial action, notice periods, communications and decision points. If you're currently non-union, you can assume that recognition campaigns are more likely to be happening, and it's worth considering, perhaps, depending on the size of your organisation, putting proper consultation structures in place yourself, things like credible staff counsel, things like that. Okay. For clients, obviously talk to your HR business partner. They can guide you on this. Next slide, please, Kat. Let's look now at the Fair Work Agency. Okay, this is really important a really important one because it's high risk and high impact for your business. From April, the Fair Work Agency will be established. This is a brand new enforcement body and is where workers and employees can go to get help. The Fair Work Agency will effectively be the police force for employment law to enforce workers' rights. Okay, they will have the power to raise tribunal claims on behalf of an employee. They will can provide legal support and assistance and representation to employees in tribunal cases. They can issue the employer with notices of any underpayments or missed payments of any of things like the statutory payments. And this agency can require businesses to show evidence of and proof of compliance to employment law. Now, how enthusiastically they will enforce these things is yet to be seen, obviously, until they start work at the beginning of April. But it's likely that they will focus on things like national minimum wage, SSP, holiday pay, and things like bad employment agency practices, things like that. So what can you do? Well, if you're in a sector kind of more at risk of minimum wage, like maybe retail, hospitality, care, agriculture, it would be a good idea to carry out an audit of your pay practices, review any deductions you might make or any unpaid training time, or if you're charging people for things like uniforms, look at holiday pay calculations, SSP processes, as things that may have gone under the radar before are likely to be picked up now. So this agency, this Fair Work Agency, has power, and we don't want your business to get caught out. It's really important to us. Okay, next slide. So we've looked at all the things that are coming in April. We haven't got long to prepare for that, only a few months. Let's now look at what's coming in October and really the things we need to be doing now to prepare for those. So the first one is sexual harassment and harassment. Okay, so if you remember in slide 10, I've already covered sexual harassment whistleblowing, all right, which comes in April. I'm now going to cover sexual harassment and third-party harassment. This has significantly more impact, perhaps, on employers. Currently, and in fact, since October 24, employers have been under a duty to take reasonable steps to prevent sexual harassment from occurring in the workplace. The new law, coming in October, extends that duty to prevent sexual harassment by requiring employers to take all of the reasonable steps to prevent sexual harassment of their employees, rather than just reasonable steps, all of the reasonable steps. Now, if you don't know what the reasonable steps are, there are a number of them. We've got a guidance PDF. Later at the end of the webinar, there'll be a QR code and you can download the PDF. So the only defence here for employers will be to evidence that they've taken all reasonable steps. Okay, so that's really crucial that you evidence it. You've got to record it and keep records. In addition, from October, employers will also become liable for third-party harassment of their workers. Well, who are these third parties? So if you're in an office, a third party might be a supplier that's come in for a meeting or a contractor that's on site. If you're in a retail or hospitality environment, this could be the bar staff being harassed by, a drunk customer. In healthcare, this could be the patient themselves. This could be one of their family members or a friend of theirs. So, and what does this mean to you as an organisation? Well, now you have the responsibility from October for managing the potential risks of these third parties harassing your employees. So you've got to be able to deal with complaints and the liability. But how do you manage the risk? Well, you might consider things like a zero tolerance policy with signage up in your workplace to communicate the policy to third parties. Managers need to be trained on what the protocol is to follow if an employee raises a complaint or, brings it to their attention. What's the protocol? Preparing staff with anti-harassment awareness training is also essential, and making sure that the managers are well trained. Taking all the reasonable steps, you need to do that, document them, and of course do a workplace risk assessment to see the areas that your employees may be exposed to this. And of course, keep a report on that. So, important that you understand what you need to do and record and report. Next slide, please. Tribunal time limits is what we're going to look at now. Again, this is high risk and high impact. Currently, most tribunal claims, including unfair dismissal, must be brought to the tribunal within 3 months of the issue that's claimed, subject to some ACAS extensions. The new law includes an extension of the time limits to bring a claim from the current 3 months to 6 months for most employee claims. This means employees have longer to think about making a claim, longer to prepare to make a claim, and longer to make their claim. So it's going to have likely a huge impact, and it's anticipated it'll significantly increase the number of claims employees may bring to tribunal. I mean, how often do you hear people say it's okay because the employee's out of time now to raise a claim, so we're in the clear? But, you know, that time frame has now doubled. So to reduce your risk, make sure you handle any post-employment grievances properly. Do also have exit interviews and conversations with your people, and make sure that you handle any issues that are raised at that point, because that will all help reduce the tension and any problems or claims raised later. So that is high risk. Okay, next slide, please, Kat. So fire and hire, the code of practice in October. Currently, this is where an employer effectively terminates an employee's contract and then immediately re-engages them on new terms that are less favourable. For example, lower pay, reduced hours or holiday or something like that. The Employment Rights Act means it will automatically be unfair to dismiss someone for failing to agree to changes to their terms and conditions, where it relates to certain restricted variations. There are some exceptions to this, and they are detailed around if there's proper evidence that the employer is in serious financial trouble, that's affecting or is likely to affect the viability of the business. Obviously, only an accountant could judge that, and the employer could not reasonably have avoided the need to make these changes. So there's quite a few hoops there to go through for the exceptions, but it only affects businesses if you're looking to use fire and rehire. Let's move on, Kat, to next slide, tipping laws. The tipping laws obviously affect businesses typically in the hospitality, service sector, pubs, restaurants, hair and beauty maybe, because currently the Allocation of Tips Act 2023 requires employers to create a tipping policy. This new law requires employers to renew their tipping policy every 3 years and to consult with employees or employee representatives on the fair allocation of tips in their business. So it's just a bit more onerous, a bit more work for you to do if your business is involved in tips. Next slide, please. Trade union rights. Again, I won't dwell too much on this. It's for awareness for you. This is coming in October. There will be a duty to inform workers of their rights to join a union. This must be done in writing upon the start of employment and at frequent intervals. Enhanced trade union rights of access will be coming in, rights and protection of trade union representatives, and protection from detriment for taking industrial action. Obviously, as this is coming in October, again, we'll have a future webinar to cover the details on that. Next slide, please. Unfair dismissal. This is really high impact, really needs attention. This, if you remember, unfair dismissal was one of the government's headline changes. Currently, only employees with 2 years service will be able to claim ordinary unfair dismissal. The new law means this qualifying period will be reduced from 2 years service to just 6 months service, allowing employees to bring a claim for unfair dismissal after 6 months of working for you. Now, you're going to say to me, well, Juliet, this isn't coming in, as your screen says, until January 2027. Why are you telling me about it now? Well, the reason I'm telling you about it now is because implementation of this will be applied retrospectively. So what that means is an employee that joins your organisation from July this year, July 2026, could make a claim for unfair dismissal in January 2027. So you only have 6 months to prepare for this change in legislation. It's going to need updates to your policies. You're going to be needing to train managers. It's going to require updates to your processes and practices to get up to speed on this before July. In addition to that, the cap on the compensatory awards, which is currently 118,223, this cap will be removed, which means compensation from unfair dismissal will be uncapped. So employees typically that earn more than 118,000 a year, their compensation will no longer be capped. But also this change is very high impact. You know, it raises the risks and uncertainties for employers, but with the right strategies in place, we can manage this. An emphasis on improving things like recruitment practices and managing probation periods thoroughly will be essential. Management training and guidance is really key here, really important. Next slide, please. So I mentioned the 6 steps. There will be a PDF on the 6 steps, which you can download at the end of the webinar. The 6 steps. Step one is an audit and an update. So to ensure your business is ready, audit every contract, policy, and your employee process to ensure they reflect the upcoming legal changes. For example, include clauses for the day one rights, sick pay, parental leave, ensure probation periods are up to scratch, grievance, disciplinaries, policies are all in line with new expectations. Step 2, risk assessment and gap analysis. Identify areas of risk to your business, contracts, SSP, unfair dismissal exposure. Assess your current processes. Look at onboarding, performance management, dismissals, grievances, to see where you will need to make changes. Prioritize the changes by risk, legal risk, reputation, cost, financial, etc. Step 3. Much of the risk comes through how policies are applied, not just what the policy says. So you do need to brief managers, train them on the modified processes, handling grievances, dismissals, discrimination, or get really good help from a good HR professional company. Make sure that managers know what documentation is changing, what they need to communicate, what the timeframes are to reduce your business exposure. Step 4, this is about reviewing your HR systems. So if you don't, because there's an enormous requirement to record and report things, keep records, if you haven't got an HR software system that operates really well for your business, now is the time to get one. It's going to be so much more important to have good quality record keeping that you can keep for many years. So legal compliance depends, on the systems. Check your payroll system can cope with the changes and your HR software is able to track things like requests, performance reviews, grievances, whistleblowing, etc. Step 5, communicate and engage with your workers, because transparency builds trust and helps avoid misunderstandings. Let employees know how policies will change and when. Update your handbook and share the changes proactively, but also listen for feedback. Employees may raise things that line managers hadn't thought of and might need some managers' attention. Step 6, monitor the law and be ready to adapt. First thing you can do, sign up for Park City's updates, we'll keep you updated for free. Consult as well with a good quality HR firm. Obviously us, we'd love to support you, but otherwise, these are high risk, high impact issues that do need action. So those are the 6 steps. Let's move on now. I mentioned some QR codes for you to scan. The one on the left gives you that 6-step process I just mentioned, so do scan that on the screen now. And the one on the right is the 8 steps to preventing sexual harassment in the workplace, with some guidance included in that PDF as well. Do download both of those PDFs. If they haven't been on the screen long enough for you, when we move on to the next slide, you will be able to obviously scan them from the recording, and you will receive the recording automatically if you signed up for the webinar, of course. So, yeah, but obviously get in touch if you have any problems at all. Next slide, please, Kat. So at the start of today's session, I asked how confident you felt about navigating these changes in employment law. Hopefully, you now have a much clearer picture of what's coming in and the 6 steps that you can take that you need to prepare right now. As you can see, the employment law changes are pretty significant, and navigating them without support can be overwhelming. That's where we come in. At Park City, we form really close client relationships. We partner with business owners, directors, and managers to provide practical, tailored HR and health and safety advice, so you can stay compliant, reduce your risk, and focus on running your business. Reach out to us, let's work together and make sure that your business is fully compliant for 2026. Next slide, please. Let's do a recap. I promise you I won't go through these lists, but you can see there what is coming in from the Employment Rights Act 2025, what's coming in 2026, the list on the left, and what is coming in to start thinking about and prepare for in 2027. We will do further webinars on this so that we can keep you up to date on those changes and anything else that comes in the meantime. But that just gives you a recap on those topics, but don't feel alone. All organisations are likely to need help with this, and we're here to help you. So whether it's updating your contracts or your policies or supporting the managers with the implementation and training them, do reach out. Next slide, please. So this QR code gives you the opportunity to tick off step 1 in your 6 steps, because you could sign up for a free audit, HR audit of either your contract or handbook, and we'll do an audit for you and give you some feedback. So that could be your first step towards stress-free compliance and stronger HR practices. But now let's open to the Q&A. Over to you, Katia.
Thank you, Juliet. So we've just got a couple of questions here. So I've got Andrew. Sick pay. Have I understood this correctly? There is no waiting time to receive statutory sick pay anymore. If I am right, does this mean that any new starter who is absent on day 1 due to illness will receive sick pay?
Statutory sick pay. So yes, there is no waiting time for statutory sick pay. However, the employee does need to be an employee for tax purposes. So obviously, if they haven't yet started, they won't be eligible. So they would have need to have started with you. So they would have need to have perhaps come in on day 1 and worked day 1, but then would be eligible for statutory sick pay.
Thank you, Juliet. And I've got another one here from Helen. Juliet, thank you. Very beneficial. We have a policy for tips in our salon. We agreed with staff, some of which are self-employed and rent space from us. We agreed how these tips would be shared. Do we still need to review this agreement? Ari, consult and update every 3 years. We only did it a few months ago.
Yes, hi, thank you for the question. Yes, you will need to. Obviously, the changes to the tipping law come in October. So from October, there is a requirement to consult with your employees about your allocation of tips policy, how you allocate them, obviously, and consult with all of your workers and people, and to review the policy every 3 years. That does come in as a requirement from October this year. Yeah.
Lovely. Thank you, Juliet. I've got another one question here from Ali. I understand most of the changes. Thank you for the detail. The change to tribunal limits is scary, but I'm confused about third-party sexual harassment. Is the law now asking my business to be responsible for someone outside my business that may act inappropriately towards my employee, someone I'm not responsible for and can't control? If that's the case, how can I be responsible and look after my team? Can you explain what I have to do?
Yeah, so yeah, that is a really good point, because we can't control the behaviour, can we, of our customers, suppliers, members of the public. We're not in control of other people's behaviour. But this new legislation comes in from third-party harassment from October, and what it says is you need to follow all reasonable steps. And so your only defence will be evidencing that you have followed all the reasonable steps. So, this is things like having a zero tolerance policy, communicating that to your customers, suppliers, people that come on site. You've seen the signs that have gone up in public places saying, we have a zero tolerance against harassment of our employees and staff, and they need to be treated with dignity and respect. Things like that have started appearing in public places already. So, yes, it is a liability, and you can't control other people's behaviour, but what you can do, and to prevent you having that liability, facing that liability, is taking all the reasonable steps. So do have a look at what the reasonable steps are, and just make sure that you've covered them all off. Talk to your employees as well about what they think can be done, because they're the ones facing the front line. They could well come up with some good ideas and give you some good guidance on that as well.
Thank you, Julia. I've got a question here from Emma. Is the unfair dismissal down to 6 months, including probation period, or does it start after probation period has been completed?
Does the 6 months start after probation period, or no? So the 6 months for unfair dismissal are we talking about, aren't we, Kat? Did that say? Yes. So the 6 months will start from day one of their employment. So the 6 months typically might well be the probation period itself, mightn't it? Some companies have a 3-month probation period, some have a 6-month probation period. But after 6 months of employment, whether that be probation or otherwise, after 6 months, that's when the employee will be able to raise a claim for unfair dismissal at tribunal. But obviously that's from the 1st of January. So if that new starter started on the 1st of July or in July this year, they would be able to claim unfair dismissal from January next year. Does that answer the question?
Thank you, Julia. I've just got a similar one from Madrula. We have a 6-month probation period with the unfair dismissal time limit changing to 6 months. Are we at any risk if we were to terminate employment at 5 months due to poor performance, for example, even if we have strong documentation to support the termination?
Would you be at any greater risk? No, I don't think so, because your protection period, if you want to call it that, is that first 6 months. So and that's of employment. So from the day one of their start, obviously check for things like, did they have any other contract with your organisation? So this does need to be a new employee, a new person joining with you. So there's no linking periods. They need to have started with you and have 6 months of continuous service. And in that period, they will have built up the right to claim unfair dismissal. So dismissing someone within that 6 months, so at month 5, as you mentioned, it is still really important to have really good, robust conversations with your people during that time, giving them the opportunity to improve performance, making sure you're documenting, as I know you do, documenting all of your probation review meetings, and your managers are having good quality conversations with their people about their performance, so the employee has the opportunity to address any underperformance and make changes. It's all of that is still really important, more so than ever before now. So yes, but no, if it's at 5 months, that's within that period. Obviously, you've got to take into account things like notice periods, so that might need a bit of checking.
Lovely, thank you. That seems to be all the questions today, but if you do have any in the meantime, please do get in contact with us, and I'll pass back over to you, Juliet.
Thank you, Kat. That's great. Super. Well, it's just really comes back to me to sort of say, thank you very much for attending. Please sign up for the next webinar. Also book your free employment law audit using the QR code there. Make sure that you stay compliant by logging into or signing up at least for the next webinar and watching it on recording if you're not available. Get clear, actionable steps for your business, and make sure that you stay in touch, contact us with any questions you have. But take care, stay safe, and thank you very much for joining us.